Justice Kennedy has some writings, some opinions to which you were referring.
Yes, there are two major gay rights decisions in the past 20 years, and he wrote both of them. And both of them were decided as a result of his vote, and both of them went in the direction of the gay rights. One of them eliminated the anti-sodomy laws in Texas and basically said consenting adults can have any kind of sex they want as long as they're adults and as long as they're consenting, and the state can't interfere with that. That's Texas versus Lawrence. And the other was a very interesting one out of Boulder, Colorado, in which the city of Boulder had enacted legislation that granted protection to homosexuals, basically saying you can't discriminate against someone before they're homosexuals because they're homosexuals. The legislature of Colorado said you can't enact any legislation that protects homosexuals. And the Supreme Court threw that out and said the state shouldn't be in the business of taking protections away from people or doing things on the basis of animosity or making decisions on the basis of sexual orientation. So when you predict what the Supreme Court is going to do, you look at what they've done in the past. If Justice Kennedy is consistent with his views on those two cases, I would think he would side with Judge Vaughn Walker on this one. Now, that's a long way off, Shep. Judge Walker has to review his own work. The Ninth Circuit Court of Appeals has to review it. Whichever way they go, only 3 of them will look at it. The losing side will ask all 33 of them to look at. Right now, we're 2 years into this process. Then they have to ask the Supreme Court, the losing side, for permission to hear it. Then the Supreme Court has to decide whether or not they grant permission. And if they do, it's another 6 to 8 months before they rule. So this is not going to end before a couple of years from now.
Well, that'll give everybody something to argue about for a few years, which is always nice to have.
Right.
There's also this matter of Fleming versus Virginia, which was an old case that I've been hearing about and reading about, which was about an African-American and a white who wanted to marry.
Okay.
And this is under the Equal Protection Clause. That's sort of how they're rooting this thing. And it's a civil rights case, is one of the arguments.
Until recently, as late as the late 1960s, the state of Virginia prohibited biracial marriages. And when this couple married
How stupid does that look now? What a bunch of fools we were. That's how this is going to look in 40 years.
It looks absurd, and it was accepted on the theory of states' rights, that the states regulate marriage and the federal government doesn't. The Congress
where you always go for bigoted stuff.
Correct. Congress wouldn't get involved. The Supreme Court got involved and said, we don't do that anymore. Consenting adults have the right to marry each other. It's a very interesting case because it was cited by Judge Walker in his opinion yesterday for the following proposition: the right to choose with whom you will cohabit and share your life is the most intimate personal choice a person makes. What business is it of the government who they choose? That's essentially what he said yesterday when he said the government can't tell you you must choose someone of the opposite sex.
And I guess part of what they were saying is if you can't tell straight couples here's how you got to do things, then you can't tell gay couples because there's equal protection under the law. And to have a specific amendment which says gay marriage is okay would be something special that I guess the opponents of Prop 8 don't want in this case.
Well, the Constitution requires that the states treat similarly situated people in a similar way. You use the phrase equal protection. So you can't have one set of laws for straights and another set of laws for gays. That's basically what he argued, or what he said. To the argument that 52% of California voters don't want this, he said, you know what? We have certain natural rights like speech and privacy and thought, and they do not depend upon the popularity of our neighbors for their existence. They come from our humanity. That's basically the argument that Judge Walker made yesterday, which I suspect a majority of the Supreme Court will accept.
We'd still be in the middle of 3/5 and no women's suffrage if we went by that, I suppose.
We would. I mean, it's hard to believe that the anti-miscegenation laws, and the reasons for them are so horrific, I don't even want to state them on the air, existed in your lifetime and mine without challenge until the Supreme Court got involved.